This is our summer honorees, our Public Service Award conversation. The Aspen Public Service Award for close to 55, 60 years has been given to people who exemplify the fundamental values of democracy with a record of coalition building in support of timeless ideals, tolerance, justice, and respect for open-minded dialogue. If you had tried to write that description, the two people who would pop to your mind are Ted Olson and David Boies. So thank you for being here. Thank you. Yes. And especially now when we're talking about convictions, compromise, and the search for common ground, it's something we've been struggling for many years at the Institute, somehow with an amazing lack of success, I've noticed recently by watching cable news. But I wanted to start by asking about your friendship. You both were the litigants in Bush v. Gore on the opposite side. Then how did you end up finding common ground on certain things? David?
Before Bush v. Gore, I think we'd known each other casually, the way you do when you're practicing law and you're representing some of the same clients and sometimes against each other. But the first time I think that we really had any serious contact was during Bush v. Gore. And one of the things that happens in a case like that is you become intensely aware of the person who's on the other side. You're spending more time with them than you are with your own family sometimes. And one of the things that happens is you come out of that experience knowing the person on the other side really well. And you know their strengths, and if they have weaknesses, you know their weaknesses. And I think one of the things that struck me in that experience was not only that Ted was a great lawyer, but his commitment to decency, to civil discourse, his integrity. I didn't always agree with his arguments. In fact, I rarely agreed with those arguments. But the arguments were always not only well put, but judiciously put and fairly put. And I think you come out of that experience, I came out of that experience with an enormous respect and admiration for Ted and what he was doing. And we had a chance to work together on a couple of things shortly thereafter in terms of his confirmation. And we got to know him and later Lady. We share a lot of things in common. We share a lot of things that are not in common, like Citizens United. We share a lot of things in common. Wine, bicycle trips. We try to always take a bicycle trip together every year if we can. We both married above our station.
Wait, speaking of which, Lady Booth Olson, Mary Boies, will you all stand up and become friends too?
And I think anybody that knows, the four of us knows that Lady and Mary are really part of what Ted and I do. I mean, when Ted and I chaired an American Bar Association committee on the future of the justice system, Mary and Lady, who are also both lawyers, were co-chairman to that. So it's been something that I think has brought us together. I think we're friends, and I think we recognize when we have conversations that there will be things that we will disagree with. There will be common ground where we will disagree and agree. But even when we disagree, we recognize that it's a part of the good faith process that you go through in a democracy. The reason that you have elections is that people disagree. But you don't have to be disagreeable to disagree.
Ted?
Well, I think people make more about our opposition in Bush versus Gore than it deserves. I mean, we were opponents in a very, very celebrated case. But I respected David and Al Gore and the legal team and the people on that side, and I think David felt the same way about the people on our side. We were disagreeing about legal principles and the way things came out, but it was always done respectfully. As difficult as it was for everybody, because this was 5 weeks, everybody remembers this, it was very tense. We were not only writing legal briefs and arguing in court, but we were out on the steps of the courthouse, and we were in that forum there in Tallahassee, talking day and night to the press, because we had to communicate our clients' points of view. But I watched David, and I thought this was enormously effective, the way David is able to capture the points that he was trying to make. And I was telling the lawyers on my team, watch him, because this is a way to learn a lot. I mean, you do have respect for the people in the legal profession that are on the other side. So it was very important that we get together after that. David was very kind. I went through a fairly contentious confirmation process, because the president named me to be Solicitor General. David helped out with that, and then we got together for other things. I enjoy enormously working with this man and with Mary and Lady together. We do a lot of things together, but I guess it comes down to the fact that we respect this country. We respect the people that run for office. We respect the law, the Constitution, the legal profession, and we try to work together. We don't really have much in the way of disagreements. We vote for different people, but we all want the same thing for this country, and it's exceedingly important.
How did you get together on marriage equality?
Well, I grew up in California. Californians adopted Proposition 8 on the same day that they elected Barack Obama to be president of the United States. He won overwhelmingly in California. That same day, in November of 2008, Californians voted to take away rights from gay and lesbian citizens to get married that the Supreme Court of California had granted them and had not acknowledged for them in May of that year. I grew up in California, and I was living in Washington by then, but I was stunned by what had happened in California. I was very, very surprised, of all places. And I was contacted not long after that by some people that wanted to mount a federal constitutional challenge under the Equal Protection and Due Process Clause to the constitutionality of Proposition 8. And I agreed immediately, because I felt the pain that we were inflicting on our fellow citizens. It seemed so wrong. But I also felt that I'm going to be not trusted by a lot of people, because I'm conservative. I've been all the cases I've done, Bush versus Gore and so forth, and many in the LGBT community aren't going to trust me, and lots of people are going to question my motives and so forth. It's going to be hard to pull together, because it's going to be necessary to have a cohesive, coherent strategy, and we're going to be going before the courts. We're going to try to change public opinion about the rights of gays to be married. The polls were 57, 58 to 43 against it at that time. This was November of 2008, the spring of 2009.
Even Barack Obama had not yet supported it.
That's right, and a lot of other very prominent politicians. So I talked over with the team that we were assembling. I said, I want to get someone who's on the opposite side of the political spectrum so that we can come together. And we readily came to David, and I called him. David took 3 seconds, I think, to agree to do this. David's a great lawyer. It's going to be a great team. We're going to be able to present to the American people, to the judges that we were going to go before, the district judges, the appellate court judges, the Supreme Court, and we had to try to change public opinion. So we were going to present this as not a conservative or liberal issue, or a Democrat or Republican issue, a constitutional issue, an American issue, so that the two of us coming together would symbolize what we were trying to say. And because it was a little bit of a tension grabber, people would say, why did you come together? How could you be on the same side? And it gave us an opportunity to write things, to appear on television, to appear on programs such as this. We did it here, the Aspen Institute, many times, thank you. But that gave us an opportunity to sell that message to talk about what the issues really were, and the chemistry was fantastic.
Well, we do think Aspen's a good focus group to
exactly.
start figuring out how to make a national argument.
The other times we did it in a bar, though, so.
Belly up.
Belly up.
Yeah, a music club, as Michael would call it. David, Justice Ruth Bader Ginsburg was here a few days ago, and she somewhat surprised me by saying that in Roe v. Wade, she wasn't yet on the court, she thought they made a bit of a mistake, which is they decided to outlaw, to strike down any bans on abortion, which was far more than they needed to decide in that very specific Texas case. And she said it might have been better to let it play out through the political process because it was playing out already and it was going to happen instead of the court doing something sweeping. Did you worry too about that when it came to gay marriage, that maybe a more narrow set of victories would have been better?
Yes and no. Yes, in the sense that I think that we wanted to be sure that the country was ready for it. But no, in the sense that I think we thought that this was not something like Roe v. Wade. This was not something where anybody's rights were going to be hurt. I mean, this was something in which you weren't taking anything away from anybody. You were simply giving to a group of people the right to marry the person that they loved. And I thought, and I think Ted thought, that once that could get established, you wouldn't have the kind of continuing opposition that you've had in the abortion context. And that proved to be right. When we won in Virginia, and Virginia was had one of the most repressive anti-gay set of statutes and constitutional amendments in the country. It was a place where there was a tremendous amount of public opposition to our case. And yet when the Fourth Circuit ruled, affirming marriage equality, the Supreme Court denied cert, people started getting married all over Virginia, and there was not a protest. Mm-hmm. There was not a blip on the radar screen. Nobody cared at that point. And what I think the thing about marriage equality is that almost everybody believes in love, believes in family, believes in equality, and that's what the case was about. I think one of the things that is troubling to both Ted and myself is the extent to which the current administration looks like it's beginning to back away from some of those principles. The Department of Justice filed a brief in the Second Circuit Court of Appeals recently in which they take the position that sexual orientation is not a protected class, which is beginning to undermine some of the principles that...
What was it declared to be a protected class in your judgment, in the case you won?
They did not do that in the Supreme Court. The Ninth Circuit did it in another case.
Correct.
But the whole thrust of the majority opinion is that all the qualifications for a protected class are there. They didn't sort of come to the language. They didn't have to. Mm-hmm. And I think that, but I think that what Justice Ginsburg was saying is right in the following sense. I think the courts work best when the courts decide the question that they have to decide. Mm-hmm. And they don't try to reach forward and decide all of the principles that they would like to see established someday. I think that if the court in Roe had proceeded to decide what it had to decide for that case, and then left to another day just exactly how far it went, what you would have seen is the country getting more acclimated to it. And I think it would have been easier to accept it. It doesn't mean that you stop short. What it means is that you progress incrementally, dealing only with those decisions that you have to make. And the problem with judicial activism, whether it's on the left or of the right, is that people get so anxious to establish a rule that they would like to see that they sometimes jump to go farther in deciding an individual case than they have to. And I think she's right about that part of it.
Ted, David just said that in the gay marriage, nobody's rights were taken away, but the case that's still percolating is like of a baker who says, look, I got a private business, I'll bake cookies or something, but I don't want to bake a cake with 2 men or 2 women being a wedding cake, and that's my right. How do you parse that one?
I don't think it's as hard as people are making it. I think that people on opposite sides of the spectrum of these issues are making it into a bigger issue than it is. If you are an individual and you're asked to sing at somebody's wedding or to be a wedding planner at somebody's wedding, that's one thing. You're performing a personal service that's personal to you and it's personal to the people that you're working for. But if you're running a public accommodation, a motel, a bakery shop, a flower shop, or whatever it is, when someone walks into that store and says, I want to buy one of those cakes, you can't say, are you gay? Mm-hmm. Can you say, oh, is a cake that you're going to buy this for, are you going to marry someone of a different race? Mm-hmm. You can't do that. That's not acceptable in our society. If it is creating a personal service that is, you have to write me a poem about how wonderful gay marriage is, that I can understand people saying, I don't want to do that. I don't care. I have personal liberty about that. But if you're engaged in a process, in a public service, a public accommodation, and I'm going into the store and I see a cake there that says, marriage is fantastic, or whatever cakes say these days. And you can put your own little figurines on top of it. Yeah. You can't say, I want to know about what your orientation is. I think that's too much. And I think that this case is coming before the Supreme Court this term, and I can't remember what the exact facts are, but some of those things, I think the court's going to work this out and say that under certain circumstances you have a right to your personal liberty, under certain circumstances you don't have to go to work for someone, and that sort of thing. But by and large, if you're in a if you put the same case before you, just change the facts a little bit. It's not 2 women or 2 men. It's a black man and a white woman. And then can the person say no? If your answer is no, they can't say no, then it's got to be the same for the LGBT people.
You said when you all won this case that it seemed to be the final victory against discrimination in our society. And yet, new things come along. How do you feel about the transgender issue and transgender bathroom? Do you think that, too, is a case of discrimination? And what else might there be that comes along that we haven't thought about?
I think that's a fair point. I think the transgender thing is something that people were thinking about. But I think that as society evolves, more and more aspects of past conduct that people didn't recognize as discriminatory, you begin to recognize it as discriminatory. A lot of the ways that I think the different genders were treated was not really thought of as discrimination 50 years ago, but I think is recognized as discriminatory today. And I think the same thing is true in the transgender. I think transgender citizens have the same rights as anybody else. I do think that one of the things that has to be done, and I think it has to be done in a way that gets everybody working together, is to try to reconcile different people's sensibilities. And that can be done, and it is being done in state after state after state. The people that say that the transgender issue is a difficult issue are people that are the same people that are still want to take us back in terms of gay and lesbian rights. What they're doing is and I think Ted is exactly right, that they are fomenting a problem when a problem really doesn't exist, because there are many, many states, and take the American military. The American military is dealing with the up until some of the recent tweets. And even after the tweets, I mean, you know, hats off to the military for saying, you know, we don't respond to tweets. If you've got a direct order, give us a direct order. But until we get a direct order, we're going along what we're doing. And what you see in diverse areas are people able to work together. Right. And when they're doing that in good faith, it works out.
Ted, why is it that, you know, I mean, as David is saying, you probably can work out a bathroom issue, whether it's a bathroom in a public accommodation or a high school, whatever, if there's a transgender person. Why is it people stoke this up these days?
I think they're looking, we said this, David said it and I said it, they're looking for an issue to divide people apart and to make an issue out of it. Right. I mean, the bathroom thing is just absurd, it seems to me. I'll tell you a story. A lady is from Louisville, Kentucky. Every year we go to the Kentucky Derby. I mean, it's like a lot of those places. There's a big, huge, giant crowd. The women's bathroom, there's people are lined up. So some of the women come in the men's bathroom and use the men's bathroom. The men don't care. So what? And the idea that people are going into bathroom to look to conduct predatory behavior, that's not where that sort of thing happened. It is foolish. This issue is ridiculous. And the same thing with the transgender. I mean, these are people. These are our citizens. They're just like us. There's a difference of sexual identity and sexual identification and that sort of thing. But the people that have been in the service for 15 years who are transgender people or are fighting for this country do not deserve to be treated this way. Mm-hmm. It's outrageous.
Well, enough of all this agreement. You brought up Citizens United.
He brought it up.
Well, and you all have debated against each other even here in Aspen a few times, Citizens United. Do you remember?
I remember this occasion. There was David and I had been at the Belly Up the night before talking about same-sex marriage, and everybody loved both of us. So the next day we were out here in the Green Wall, and there's a couple thousand people in there, and we were debating for the fun of it, Citizens United, and we flipped a coin. I got the side that defended Citizens United, and there was one person I know who sat in the front row was David Koch, who was on my side. Now, 2,000 people were on David's side. Same people.
And those are pretty good odds.
So now Citizens United has gotten, by the way, Floyd Abrams has defended the position of the Supreme Court. I've asked people, in the first place, I won't go and spend a lot of time on Citizens United. A lot of people think that Citizens United is to blame for all the money in politics. It isn't. It had to do with a specific, over-broadly written statute that covered all corporations, no matter how much money they had, whether they were nonprofit corporations, whether there was any, suspicion of improper behavior or anything like that. And it created a felony. It would have been a 5-year punishment if you wrote a book mentioning a political candidate, a federal political candidate, within certain many days of the election. When the issue of, I made the argument to the Supreme Court, I said, this statute would cover books. And the Solicitor General, who is now on the Supreme Court at the time,
is Elena Kagan?
That was argued twice. She argued it the second time. The Deputy Solicitor General said, well, yeah, I guess it would. And we were talking about corporations, which are book publishers, by the way. All the book publishers are corporations, and they're sort of all foreign corporations, as a lot of people know.
Not Simon & Schuster.
But no matter where those corporations are, if you've written a book, one of the justices asked that question, and the Deputy Solicitor General said, yeah. And then when Elena Kagan got there, and we argued it the second time, she said, well, she backed away from it. She said, well, maybe not books. Mm-hmm. And one of the justices said, what about pamphlets? And she said, well, yeah, pamphlets. And I thought, I won this case. Mm-hmm. Pamphlets, do you remember pamphlets during the Revolutionary War? Do you remember the Federalist Papers and all that stuff? At any rate, I think that the people that oppose Citizens United have very, very good arguments to be made. There maybe could be some reforms to the system, but I've yet to hear someone say, we are going to amend the First Amendment, or we're going to change it in a way that inhibits people from expressing themselves. By the way, the statute there prohibited corporations and labor unions. So the AFL-CIO was on our side too, as was the ACLU, as was the NAACP.
But it was basically for you a free speech First Amendment issue. Do you believe that that money in politics is a speech issue, and the ability to spend money is a speech issue?
People say money isn't speech. And I said, well, this microphone, yeah, David says that, and despite the fact that we talked last time when we were here talking about it, I was asking about which one of his clients, you know.
Yeah, right.
But
That is true.
I would say that to people who say money isn't speech would say microphones aren't speech, billboards aren't speech, placards aren't speech, mass mailings aren't speech. In order to communicate your message, you can't just have your voice. You have to amplify your voice. You have to be able to talk to all over the country. That means you have to have a microphone. You have to have a television ad. You have to have a book. You have to have various means of amplifying your voice. So the Supreme Court has said, and Citizens United wasn't the first case at all. The New York Times versus Sullivan involved a newspaper ad. And by the way, the New York Times is one of the most vocal critics of Citizens United because it allowed corporations to say things about politics during elections. The New York Times is a corporation, and they do it all the time. They do it, and they would fight for that right. And that's why Floyd Abrams, who's one of their lawyers, has come out on the same side that we are on the thing.
All right,
it is a complicated issue, and maybe there are ways to tell people, and if we have Congress deciding who should spend money, how they should spend money, Congress will pass laws protecting incumbents. And they will do that every single time. And so if you have government deciding who should speak, how they should speak, how much they should speak, how forcefully they should speak, that is the antithesis of the First Amendment. Lots of speech, robust debate, the government stays out of it. Congress shall pass no law.
David?
I think Citizens United is probably an excellent example of what Justice Ginsburg was saying, which is that it took a case that could have been decided on very narrow grounds, that could have been decided on simply the grounds that really Ted was articulating in terms of this was a corporation. It had done a documentary. It ought to be considered free speech, and they ought to be able to publish the documentary, including during an election. I think the Supreme Court could have decided that case the way Ted argued it the very first time, without doing the kind of damage to our political system that I think the actual Citizens United opinion has done. Because what the court did, contrary to the sort of judicial restraint principle that we were talking about in a different context, is they reached out in this case that could have been decided simply on free speech grounds and decided that they were going to strike down, in effect, limits on campaign financing. And it's one thing to say you want to have robust speech. I think I would 100% agree with that. The government should not be in the position of saying who can speak, or when, or what they have to say. But I think that there is reasonable grounds for difference of opinion as to whether money is speech. I also think there's reasonable grounds for difference of opinion as to whether corporations are people. So I think that when you go as far as the Citizens United opinion did, which was far beyond what the Citizens United case was about, and you say that you are going to have unlimited ability of large institutions, corporations, or labor unions to spend money, that begins to corrupt the political process. It deprives people of the effective right of speech, because individual citizens in a community confronted with somebody who is spending millions or tens of millions of dollars on a congressional race do not have an effective ability to speak, because their speech is being drowned out by the money that is being spent. And I think that if you look at what we want to have, and if you look at the kind of freedom of speech that was contemplated by the founders, it wasn't where somebody was going to buy an election. It was where everybody got to get out and write their pamphlets, distribute them, speak on street corners, in newspapers, and however they wanted to do it. But when you begin to translate that into campaign contributions that are unlimited, I think you're only beginning to see the problem. And the problem is, I think, less at the presidential level, maybe even less at some of the Senate levels, okay? The problem is at the local level. The problem is in local races where $100,000 or $1 million can make a tremendous difference in terms of somebody being able to have a level playing field. And I think that is the real problem. And I think that I don't think that's going to change until the composition of the Supreme Court changes.
Ted, is there any permissible limit on the campaign spending and financing in your opinion?
I will say this. David mentioned contributions, unlimited contributions. Citizens United had nothing to do with contributions. There are limits that have been upheld by the Supreme Court on contributions. This had to do with how you spent your money independently on advocacy. That is the that was the issue. It was expended. Well, David, go ahead.
But I don't think that's a really accurate description. I mean, what it did was it said it didn't have to do with how much you gave to the particular candidate, but you could spend all the money you wanted supporting that candidate. And the idea that these are independent contributions, that the people who are running these PACs are independent, and this is true for the Republicans and the Democrats, okay? You have the congressional PAC for the Republicans and for the Democrats that are run by former staff people of the leadership. Those people aren't independent. You have
horrors.
You know, so it's not independent. So I mean, so
they have their own view that identify
with. It is campaign contributions, you know, in every practical sense of the word. And I think that if you believe in campaign contribution limits of some kind, then you've got, I think, logically to think you're going to have some kind of limit in terms of how much money that can be spent in terms of supporting particular political candidates. If you don't, what you do is you end up with what I think we have now, which is this facade of pretending that these are independent, and they're not independent. And even if they were independent, that doesn't change anything because it has the same effect whether you are making a, quote, independent expenditure or a candidate expenditure if the advertisement says
it's
the same
very,
thing.
it's, Citizen United had to do with people spending money on their own, making their own decisions. They may have had an identification, they almost always do. The reason people do this is they want somebody to win. So that doesn't make them not independent. And if you can prove that there is a link, some conspiracy going on, use the word collusion, which is the whole world is understood now all of a sudden, then there's a problem. But the problem is, at bottom, government regulating the participation in the political process. So you start saying you may only spend this much money, and there will be limits on it. You can spend 1/4 of your fortune or 1/10 of your fortune to elect the person that you think would be the best person to be president of the United States. When the government gets involved in that thing, when government gets involved in the process, and it's not a question of whether corporations are people. The New York Times will say corporations have constitutional rights. They have Fifth Amendment rights. They have rights to be free from searches and seizures. They have rights to speak whatever they want to say. So, and it's labor unions too. It's other kinds of associations. So the First Amendment says Congress shall make no law. It doesn't say some people are protected by Congress shall make no law. But and my point is, and I'd like to see the person come up with a First Amendment, the ones that I saw that have been suggested in Congress are all very flawed because they're going to get the government, law enforcement, involved in deciding how much of your fortune, how much of your energy, how much of your time, how much of your passion you can put into electing the person of your choice. Well, if you have to choose between the government deciding that for you and people running around spending lots of money on both sides and letting the people decide which arguments they like best, I prefer the latter. And so there's the First Amendment.
All right. Justice Ginsburg said the most important case they're going to do next term is gerrymandering. Give me an argument. I'll start with you, Ted. Is there a constitutional issue involving equal protection or one person, one vote, whatever, on the extremes?
Where'd you come up with all these easy questions?
Well, you would have to argue that if you were.
No,
which way would you argue it?
Who's hiring me?
The American people.
What the Supreme Court has done on numerous occasions is said that gerrymandering, which is drawing congressional districts or legislative districts in a way to provide an advantage to whoever's drawing those districts. If they're done in a way, as they were for many, many years, to disadvantage persons of a certain race, the Supreme Court has said that violates the 14th Amendment. You cannot do a racial gerrymander. And they've struck down many of those, including just this last year or so, in efforts to parcel people up into zones. Because if you put lots of people in one zone and then distribute the others, you're going to be able to elect more people than a random population distribution would be. Now, the question that's coming before the court, and has come before the court a couple of other times, is partisan gerrymandering. If the Democrats in Pennsylvania redo the districts so this happens every 10 years, and more often than that in state legislatures, so that the way the population is, and you can get very scientific about this now with computers, they can go by districts and they can draw all these lines to pick up all the Republicans in this district and make Democrats win in this, or vice versa. Both parties have done this for history. They all do it, and and they do it to put their party in the best position for the number of districts and so forth. And they will do it in a bipartisan way, in the sense that they will protect people of the other party if they're incumbents.
Right.
So these are incumbent protection measures as well as party protection measures. So the last time it came before the Supreme Court was a case involving Pennsylvania, and four of the justices said, well, there's got to be a constitutional limit to this. It violates the concept of one person, one vote, or equal protection, and so forth, because the districts are being distributed unfairly. Those four justices had four different theories about what the test would be. The other five justices, four of the justices on the more of the conservative side, said, no, this is politicians being politicians. That's what they do. So they get to exercise this power, and there's no way we're going to be able to get courts involved in deciding that. Justice Kennedy came down, it was a 4-4-1-4 decision. Justice Kennedy said, I sort of agree with the majority, at least in this case, but I think there could be a case. Now, so he's still on the court. So this case, which comes from Wisconsin, might be that case. A lot depends upon how he decides it. Justice Scalia, writing for the majority in that Pennsylvania case, said, I noticed the four justices on the other side of the court each thought there was a different rationale and a different way to solve the problem. If they four can't make up their minds, how could we do this for the country? So it's going to be, and I won't say how I would argue it, I really think you could make an argument on both sides. However, I do think at the end of the day, again, the idea that people drawing districts to favor themselves, that's a political process, and you've got to be pretty careful. You get judges, a district judge in Wisconsin in this case, a district judge in Maryland in the next case, deciding what's fair, what's not fair. How do you determine? There's a lot of argument about how do you decide that it's been unfair. Is there a 5% differential, 7% differential? If you had a perfect mathematical process, it's going to be very hard to come up with solutions, jurisprudentially recognized standard that you could apply case after case, and I think that's gonna make it difficult for the court.
I think the last thing Ted said is exactly right, which is that the difficulty I think the court's going to have is trying to figure out how to implement the standard. 60, 70 years ago, the court viewed all districting decisions as political questions. In Baker against Carr, first began to say you've got to have equal population districts. And then under equal protection, and I think the equal protection argument was actually an easy argument, said you can't discriminate against a protected class. But Republicans and Democrats, neither are a protected class. And so I think that it's going to be very difficult for the court to figure out if they want to eliminate gerrymandering, and I think most people think gerrymandering is probably not a great idea. But if you wanted to eliminate it, how could you come up with a standard that can be implemented? And my suspicion is that Justice Kennedy is going to come down with the 4 conservative justices on this issue, not because he is in favor of gerrymandering, but because I think he is going to worry about how are you going to be able to implement that, how are you going to be able to do that? And I think you're going to throw it back to the political process, and maybe you come up with a political solution for it. I don't think the political solution is for some states to not gerrymander and other states to gerrymander. I think that's unilateral disarmament. I think what you're going to say is a movement, if the court does what I think it's going to do, I think you're going to see a movement towards more gerrymandering until finally the American people say this is just too much, and they solve that politically. But I don't see this being something that the courts are going to be able to do.
So Arizona, California, several other states have passed initiative measures changing their constitution,
right,
putting the process into an independent agency.
Yeah.
The Supreme Court last term or the term before upheld Arizona's procedure whereby they did create an independent institution to do this sort of thing. So David might be right. The American people might get sufficiently upset with Republicans here, Democrats there, doing this thing that they might follow that trend. I had drinks with Arnold Schwarzenegger, who's set up an institution, the Schwarzenegger Institution in California, that is trying to get that idea across, to sell that idea across the country, that there should be more of these programs that set up independent, take it away from both Republicans and Democrats, and do it that way.
Right.
The last easy question I have before we go to the audience is, here at Aspen, at any given moment, somebody's saying, can you call up, the admissions director at Harvard and give a little gig for my nephew, or an internship for my niece, or whatever it may be, which I call affirmative action for privileged people. And I always write the letters because I'm always in favor of that. But it also makes me feel that the question of affirmative action is not as easy as people who seem to come down strongly on either side. How would you deal now? I know Harvard's being, the Trump administration is coming down on the side against Harvard, which was following the Michigan decision to say we will try to judge each person on merits, but also have a good mix. How would you solve affirmative action now?
Well, that's insoluble. what the Trump administration is doing, finally, in a brief, supporting private litigants suing Harvard, and I think there's a couple of other institutions, that on behalf of Asian Americans who say that they are being discriminated against in the admission process because there are quotas for them. This is going back a long time. It used to be quotas, 75 years ago for Jewish people in these institutions. You didn't want too many.
But we're all against quotas. Let's
Right, yes, okay, but no one wants to call it a quota, so they won't, no one will say, oh, we've got a quota. They'll say that we use a holistic process to look at everybody's background, where they came from, what color their hair was, whether they were in
That's precisely what the
sports.
Supreme Court said to do in Michigan.
And so that allows you to do whatever you want to do. So you can decide, they won't write this down. They will say, we want a certain mix of races and so forth. Sometimes they do it on that basis or ethnicity, or they call it poverty or something. That's one of the covers that they use. But what they want to do is have a diversity in the student body based upon race, ethnicity, and so forth. And then they do in the admissions
And what's
process.
wrong with that?
Well, what's wrong with that is that if they're trying to accomplish the same thing as a quota, then there are significant equal protection clause issues. It's been going on in California for a long time with respect to Asians. The Asians trying to get into the University of California, of which I'm a graduate, have not been able to get in the same numbers as their scores in their academic record, their scores on tests, the other standards that you usually look at would allow them to do, because there's other considerations that the admissions process feel are more important.
But why are scores on tests that important?
Well, it's like, why are the times that you record when you run the 200-meter dash important?
No,
David?
I don't know.
Well,
I don't know
let
if
me
that's the
finish,
same.
David.
Okay.
So you knew it would be good to have some sort of neutral standards with respect to how you decide the admissions process. The more subjective it becomes, the more subjective you can do in determining the outcome. Now, what is the purpose of the university? If it is for the purpose of bringing an equal number of this component or that component of your society together to get a higher education, no, that's fine. But if you have one place where you want to have high achievers getting the best education, taking people that aren't able to achieve at that level and putting them in that, at Stanford, for example, is not a great thing for them, because then they're competing against people that run that 200 meters in a faster time, and they won't be able to compete fairly. So I'm not saying there's a flat answer to all of this. That's why the Supreme Court's been into this since 1976 in the Bakke decision. There's been something like 10 different Supreme Court decisions on this issue. The justices are all over the place. In the Michigan cases, they came out 5-4 in favor of the law school at Michigan, and they came 5-4 against the undergraduates at Michigan. The same Board of Regents trying to do the same things. One was constitutional, one wasn't constitutional. I counted the number of opinions from justices in those affirmative action cases from 1976, and there was something like 25 different opinions from justices saying what's constitutional, what's not constitutional. And one might say, what is a school board to do? What how do they figure this out if the Supreme Court can't figure this out?
David?
Let me begin by agreeing with something that Ted said at the beginning, which I think this may be an insoluble problem. And the reason, again, is the difficulty of standards. I think most people would agree that quotas are bad. Although I think that, as Ted is saying, it depends a little bit on what you mean by quotas and exactly how firm they are. But I think most people would also think that diversity in a educational institution is a good idea, that you educate people better in a diverse environment than you do in a less diverse environment. Now, you don't want to use affirmative action or whatever you call it to put people who are not able to do the work into the university. But if you take Stanford, Berkeley, Yale, Michigan, lots of universities, you have 2, 3, 4, 5, and maybe in some cases up to 6 or 8 times as many people who are qualified to do the work as you're going to be able to take. The distinctions that a school like Stanford that you mentioned makes in terms of who they admit and who they don't make is not a distinction as to who can do the work and who can't do the work. They have a pool of people who are going to be able to do the work. The question is, do you make it strictly in terms of who has the best test score, who has the best grades, and if you do, how do you weight grades and test scores? Or do you take into account other factors? And if you take into account those other factors, how do you do it? And that's what makes this so difficult. That's why you have these Supreme Court opinions that look so inconsistent. That's why you have so many different Supreme Court opinions, and they're so close. That's why the Michigan regents get affirmed 5-4 in one and get reversed 5-4 in another.
Same day.
Same day. Same court. Same regents. Because these are very difficult. These are very difficult issues. Now, I think that to some extent, the answer needs to be to give educational institutions some leeway in making those decisions. I think that one of the reasons that the court, in some of its opinions, has talked about quotas are bad, but a holistic approach is good, even though those, I agree with Ted, tend to meld into each other at the edges, is because if something is egregious, too egregious, then the court is going to stop it. But in terms of the university's goal of trying to create a diverse student body that is not only good for the institution, but I think it's good for the country. I think institutions need to be given a certain amount of leeway there. The court ought not to become a super school board. I think one of the ironies is that the left and the right in the courts just flip-flop back and forth as to how much judicial activism they seem to want, depending on what the kind of case is. And in this particular case, I think that the more conservative justices would be, well served by thinking that they may give the educational institutions a little more of the leeway that they want generally to give law enforcement people.
Mm-hmm. I'm going to open it up, but as people get ready, one quick thing for you to get to out of the Constitution into current issues. You were Solicitor General. There's now a special prosecutor, a recused Attorney General, a Solicitor General, and Deputy Attorney General, all dealing with the investigation that Mueller is doing. Explain who each of these people serves.
Well, the Solicitor General is not involved in this thing because the Senate hasn't confirmed, or maybe it did last week, I don't know, Solicitor General. That's been a long time coming. What you're supposed to do in the Department of Justice is represent the United States, but you are part of the executive branch. And so the Solicitor General and the Attorney General, the Deputy Attorney General, and the head of the FBI are part of the executive branch. The executive power of the United States, says Article 1 to the Constitution, is vested in the President of the United States. So the President has the responsibility to execute the laws, which means it has responsibility to determine what the Secretary of Treasury policies are and so forth. On the other hand, with respect to the Justice Department, there's been a culture there, for very, very good reasons, that the President's politics and partisanship stays out of the Department of Justice. Now, that's a very tricky situation. When you talk about antitrust, for example. What is the antitrust policy? What is the antitrust with respect to mergers going to be? What are the guidelines there? That's a political question. What is the telecommunications policy going to be? And the Justice Department gets involved in that. When there's an affirmative action case coming before the Supreme Court, the president has a sense of a responsibility to decide, well, is diversity a compelling governmental interest, and that triggers the standard by which this is going to be measured, or isn't it? Those are political questions. When I was in the Justice Department in the Reagan administration, in the Office of Legal Counsel, and in the Bush administration as Solicitor General, we felt, and the Attorney General in both of those administrations felt strongly, that the president had a role with respect to certain types of questions, but that the president would basically respect the independence. Independence is a word in quotes because you're still a part of the executive branch, of the decisions being made by the persons in those capacities. And I felt at OLC, the Office of Legal Counsel, which is responsible for writing legal opinions, and the Solicitor General, you're responsible for making arguments in the Supreme Court and deciding appellate issues, is to the best thing for the president is for those decisions to be made on the merits. You get together the FCC, the Antitrust Division, the Civil Rights Division, and then talk it over and decide what are the best arguments to be made, or what's the best legal decision, and the president really needs to stay out of that. And so over the years, guidelines have been developed. The White House is supposed to only communicate with the Attorney General in a certain way. But on the other hand, you have to communicate, the White House has to communicate with the Justice Department with respect to proposed legislation. I mean, it's much more complicated than that, but it only works if the president does have that respect for the institution, because if the institution of the Justice Department lacks credibility with the American people or with the Supreme Court, then that's bad for the president, it's bad for America. When you're in that position, you are not just, you swore an oath to the Constitution, not to the President of the United States. So this business about loyalty is very badly been very badly characterized by this administration, or clearly misunderstood.
Yes, right there. I'm sorry, the light's in my eyes, so I can't quite see.
Hi. With Citizen United, given that we don't know the big bucks, who's giving the big bucks, aren't we more open for foreign influence and interference? And if so, how would you fix it?
Well, the question is, if you don't know where the money's coming from and you don't know where it's going, how are you going to fix that, or how are you going to regulate it? The idea that Citizens United didn't involve foreign money, the Supreme Court specifically said this doesn't involve those provisions that involve money coming in from foreign sources. There are statutes on the books that have been respected and still are the law of the United States. So on the other hand, it's a little tricky when you talk about foreign money. The major corporations in the United States are owned by people all over the world. The stockholders, you can be from India and buy. The New York Times has a lot of stock owned by one of the richest men in Mexico. So what is a foreign person? What is foreign influence? And so that's a very difficult thing to do. So when you try to develop rules with respect to that, that it involves disclosure by the candidates and or the contributors. But if you're spending money by yourself, to what degree can the government say, I don't want you, the Citizens United itself was a 90-minute documentary by a nonprofit ideological corporation that was called Hillary the Movie or something like that, and it thought the 90 minutes, it was quite clear the people making that movie didn't like the idea of Hillary Clinton being president. The guy who created that company said, I got the idea from Michael Moore. He's making all these movies that he's expressing political views, and everybody thinks it's just really terrific for Michael Moore to do it, so I want to do it too. I want to do it, make money, and express my views.
But real quickly on the disclosure issue, should you be able to do it anonymously?
That's, again, a very difficult question.
I don't know the answer.
Here's what the issues are. You decide. The Federalist Papers were written anonymously. The Supreme Court held in a case called McIntyre a couple of years ago that a person in Cincinnati who was distributing petitions against the city council because she didn't like what the city council was doing was entitled to distribute those petitions anonymously because she was afraid of the impact. The Supreme Court decided in a case called NAACP versus Buttons that the NAACP did not have to disclose their measures and their contributors because of the political consequences. So in one sense, we'd like to know what everybody's spending money on and who's in favor of what. Because we would know more about who's supporting whom and who's receiving money from where. Then we could make more intelligent decisions. There's no question about that. On the other hand, anonymity in the process, speaking our own views, or becoming, the First Amendment protects not just speech and press, but association. Do you want to require any organization to require that organization or the members of that organization to disclose what organizations they're a part of? So there's values on either side of this one, and I'm ducking the question. I think that yes, I am. So,
David, do you have an unduck?
I do. The initial justification for, one of the initial justifications for Citizens United was that, people can find out who's making these contributions, and if they don't like too much money coming from a particular person, they can react to that politically. I think that if you're going to have Citizens United, you have to have disclosure. You have to know who is spending this money. I think part of my reasoning is I don't agree. I mean, the First Amendment says Congress shall make no law, but it then goes on to say, with respect to certain things, and one of them is not campaign contributions. And so I think that if you're going to have unlimited ability to spend money to elect an official, if you're going to be able to have these super PACs that have an unlimited amount of money that they can spend, I think the American people ought to know who's putting that money in there. And if it is a foreign corporation, I think the American people ought to know that. If it's a foreign government, I think they certainly ought to know that. If somebody from Russia wants to make a huge investment in the political process here in the United States, I think we ought to be able to know that. And if that's done through a corporation that is partially owned by the Russian government, I think people ought to know that. I think disclosure is good. I think there are times when you're protecting what people are doing, not what they're spending, what they're doing, what they're saying, that their identity ought to be and can be protected. But I think in terms of, and part of it has to do with my view that talking is different than spending. If you don't agree with that, then maybe you say that you don't have disclosure here.
Yeah, both of you, but I'll start with Mr. Dickey and then Mr. Walling. Yeah.
Thank you, Walter. Walter, thank you, and thank you both. It's been terrific. Could you, either of you, say a bit more about the statute that the Supreme Court was dealing with in the Citizens United case? I gather it was a broader statute than it might have been. And as a corollary, why hasn't that statute been amended to confine it to more defensible grounds?
The statute was part of McCain-Feingold, which was upheld by the United States Supreme Court a couple of years earlier. And I was Solicitor General and argued that for upholding McCain-Feingold under the challenges of the First Amendment. But this particular part of that measure that had to do with reforming campaign process made it a felony for money to be spent by a corporation and if it named a candidate for political office within so many days of a general election or so many days of a primary election. I've oversimplified it because it is a little bit more complicated than that. But basically it said to all corporations, and all expenditures not contributions, but expenditures. You might argue that expenditures are just like contributions because they help somebody, but that it's expenditures and not contributions. So that if you published a book, if you were Random House or something like that, and published a book within a certain number of days of the election, and you named Hillary Clinton favorably or negatively, then you would be violent. Then it would be a felony, 5 years in prison for publishing that book, or a pamphlet, or any other thing. There were 30-second ads, 90-second ads. I mentioned the movie because this was a 90-second exposition of why that person didn't think Hillary Clinton was qualified to be president. And he particularly did. He said, I can get away with this because Michael Moore can get away with it.
But should it have been decided more narrowly?
Should it have been decided more narrowly? It could, and we argued it twice before the Supreme Court. You could have said, well, 90-minute documentaries are going to be permitted under this First Amendment right, but 30-second commercials aren't. Where are you going to draw the line on there? You could also have said this was pay-per-view. You had to request it. You could have made, then the arguments were being made, well, it shouldn't apply to pay-per-view because people are asking for that information. The Supreme Court couldn't decide, well, now how do you decide what pay-per-view is and people turn, so that was a line that they didn't feel comfortable with. They talked about, well, maybe we'll draw a line for just for-profit corporations versus non-profit corporations. And then they decided, well, that's going to be very difficult. Maybe it should be really wealthy corporations because you don't want to have big money in it. But this was a corporation that had no money at all. This was a corporation that 1% of their funds for the movie was from a corporate contributor. You could have drawn the line there. But each one of those lines, I'm going through all of this because it was all litigated. And when you start drawing those lines, they're pretty hard to draw. And remember, if you're wrong, if you're the speaker and you're wrong, you go to jail. And he went to the Federal Election Commission and said, can I produce this movie? And they said no. He didn't dare take a chance. Because if he was wrong, it would have been a felony. And that inhibits, in and of itself, speech.
Mr. Wallach? Yeah.
You mentioned Gore versus Bush. A couple of years ago, I had the opportunity to speak with Secretary Clinton and President Clinton about Fahrenheit 9/11 and how horrified I was to see 100 senators deny African-American U.S. Congresspeople the right to address the Senate. President Clinton said there was something worse, and I asked what. He said, in the Supreme Court decision, there's a paragraph that says this decision is never to be used as a precedent for any other decision.
That's a good point. I know you really fought that, so let me let David take that one.
It's not quite as absolute as that, but
you might run us restate the question.
The question was, in Bush v. Gore, there was, President Clinton had said a portion of the opinion that says this is not to be used in the future. It's a little bit, that's the substance of it. It's a little bit less absolute than that. But I think it reflected that you had a very divided court in the per curiam opinion. You had 3 justices of the court that had a coherent principle, and basically the principle that Ted spent most of his brief and most of his argument arguing for, which if it had been decided on that basis, and it had to do with whether how the powers were delegated to select electors. But they couldn't get any more than 3 for that point of view. And so they had to decide it on equal protection grounds in order to get O'Connor and Kennedy. And 3 of the justices that were in that majority were extremely negative about using the equal protection clause for this kind of situation where you were dealing with an ad hoc situation. For example, the 3 most conservative justices in that 5 justice majority had written a number of opinions in which they had said that the Equal Protection Clause could not be applied in situations where you did not have a systematic discrimination. That is, where, for example, a prison guard takes away books from particular individuals in a discriminatory manner. That was not, according to these three justices, equal protection issue. And so this decision, if it had been real equal protection precedent generally, would have greatly expanded equal protection law. And I think they didn't want to do that. So I think that people wanted to get this election resolved. They wanted to get it behind the country. They wanted, as Justice Scalia was wont to say afterwards, they wanted people to move on. But they did not want this opinion to be used as precedent. And one of the things that happened is that not too long after that, there was a case coming out of California where people sought to use this as precedent, sought to get to the Supreme Court, and the Supreme Court did not take the case. There's a reason Bush v. Gore, it's been almost 20 years now, has not been cited, and I don't think will be cited for this kind of proposition, which is it was a one case opinion, and the principles were, and I think that you can argue that that's a bad way to decide things, or you can argue that in this particular case it was a good way to decide it because you had to make a decision. But my own view is more in line with President Clinton's.
Okay, final question. Ann, is that you? Yeah.
Another easy question. Walter, right at the beginning, you talked about Justice Ginsburg talking about Roe v. Wade and whether that was too sweeping a decision. So at the current moment, do you think we are perhaps one justice away from reversing or restricting the Roe v. Wade decision?
Two things. I think there is a distinction between saying that Roe v. Wade was too sweeping a decision and saying that Roe v. Wade as a sweeping decision was too early. I think Justice Ginsburg would say that the process should have proceeded more incrementally, but I think she would say it should have ended up with the Roe v. Wade decision. I don't believe we are one justice away from reversing Roe v. Wade. However, I think we are one justice away from severely restricting the scope of that. The court has been restricting the scope of that. And I think that if you had one more, it obviously depends who the justice is, but if you replaced one of the four liberals or if you replaced Justice Kennedy with somebody comparable to the most recent appointee to the court, I think you would see very significant restrictions from very significant changes in existing law in terms of restrictions on abortion.
And Ted, I'm going to let you have the final word, maybe broaden it a tiny bit, which is, could the Supreme Court, with another justice or two, reverse or restrict severely Roe v. Wade, and even the case that you were involved in, which is marriage equality?
I don't think, David might be right, the court has the power to reverse constitutional decisions, and it has in the past. On the other hand, it has been, most of the justices are very, very concerned about reversing established precedent, especially a precedent like Roe versus Wade, which has been affirmed over and over and over again. The court had a chance a few years ago to address the Miranda decision, which is very, very controversial, and a decision written by Chief Justice Rehnquist, who had been very critical of Miranda, said it's a part of the fabric of our society. We're not changing that. I think the justices, the conservative justices, which is what we're talking about now, are respectful of precedent and very, very cautious about the impact of precedent. Roe versus Wade is a very, very special thing. I mean, it draws out enormous passions from people who feel very, very strongly about ending a fetal life, and on the other hand, feel very, very strongly about the right of an individual to control that process if it's taking place inside their body. And the underlying concerns about that animate Roe versus Wade animate the same-sex marriage case. It's an issue of privacy and dignity and individual decision-making, which comes about through a long, long line of Supreme Court precedents that, whatever they were at the time they were decided, Griswold versus Connecticut was sort of the breaking point there in terms of an individual right to privacy. The critics say, where is that in the Constitution? Well, it's all over the Constitution in terms of the Fourth Amendment and other provisions of the Constitution and parts of the Constitution that have to do with conscience, such as speech, assembly, press, and that sort of thing. So I think severely limiting, I don't know what those cases would be. They're coming up. Their legislatures are fooling around with these things. But I personally think this is a matter of prediction, not wisdom now. So I don't think that Roe versus Wade is going to be overturned, even if there is a replacement for Justice Ginsburg or Justice Kennedy with a conservative justice. And I will just say for the record that I disagree with everything David said about Bush versus Gore. And I won't go into all of the things about the Equal Protection Clause and so forth, but I do, you could see why I came away with so much respect for how he presents his opinions.
I want to thank you for taking a step of Constitution and the House. Thank you. Perfect.
Thank you. Couldn't be done. Thank you. Perfect.